Justice.
All rise. Please take your seats. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Barbados, CCJ Appeal number 5 of 2018, between Octavius John and Laurent John versus CLICO International Life Insurance Company Limited. This morning proceedings comprises the hearing of the appeal and an application to strike out the notice of appeal. Can we have the appearances for the court, please? Thank you.
May it please the court, Your Honors, I am Zyda James, and I appear for the appellants, Laura John and Octavius John. With me is Mr. Kevin Miller, attorney at law, and the second appellant, Mr. Laura John, is also, Laurent John is present.
My lords, my lady, Ramon Allen of Clark, Gittins and Farmer, with Mr. Michael Coyman on behalf of the respondent applicant in the matter.
Okay, good morning, Counsel. There are two main issues before us. One is the preliminary issue as to whether the appeal has been rightly initiated, and then if, and assuming that the appellants get past that hurdle, there is the substantive aspect of the case. What I would suggest is that Mr. Coleman, Mr. Allen, you should address us first, not for long, on your objections to the right of the appellant to initiate the appeal. And then we will hear from Ms. James, and then Ms. James, you will make your arguments on the substantive matter, and Mr. Allen, you will respond, if you wish, to her response to you on the preliminary point and also on her arguments on the substantive matter. So can we begin with you, Mr. Allen?
Thank you, my lord. My lord, the preliminary issue is what I would consider a jurisdictional one. The subject appeal relates to an interlocutory application, and that is our position. And this court has spoken clearly on the issue of interlocutory appeals and as to whether there is...
Why do you say that this is an interlocutory matter?
The application for a stay, my lord, is by its nature, I would say, an interlocutory, as it does not deal with the lifting of a stay is by its nature the dealing of an interlocutory application, as it does not deal with the substantive substance.
Was it an application for leave to initiate proceedings against the judicial manager to enforce the judgment?
Yes. Yes, my lord.
So, if that application succeeded, is it that a new proceeding would have to be launched against the judicial manager?
Let me see if I understand you, my lord. Could you repeat that question, please? If the application...
The Johns filed this application to the court to begin proceedings against CLICO. If they succeeded in that application, would they then have to file new proceedings against CLICO?
Yes, my lord.
So that whether we take it as the application test or the order test, the result of the application that they had filed would bring to an end these discrete proceedings. They would either be refused leave, or if they succeeded, they would then have to commence new proceedings.
But Lord, I must admit my concept and view was that the initiation of an application to lift the stay is one and substantive part of the proceedings to enforce the judgment. The fact that they would have to file a further application after they have applied for the lifting of the stay, in my mind, does not make it any other than a first step in the proceedings.
Yes.
Which is Hampton Allied. My lord, we would have made reference to Hampton Allied Bakeries Limited in our filing submissions. This would have been page 882 of the bundle, where the position was held that where an order staying proceeding has the character of a final order, it is nevertheless an interlocutory order. In determining whether a matter is final or interlocutory, practitioners should look up the practice books to see what has been decided. Hampton Allied Bakeries, the Court of Appeal, considered an appeal from an order which struck out most of a statement of claim and stayed all further proceedings, effectively precluding the plaintiff from ever litigating the claim.
Yeah, but that was a judicial stay, wasn't it, Mr. Allain? This is a rather peculiar statutory stay. So it doesn't necessarily follow that the same principles apply.
But Lord, certainly there is the possibility, but we took the view that the nature of the stay, though grounded in a statute, did not necessarily change on this substantive point. And we do have, yes, a statutory position in terms, but this was also pursuant to the stay was always also pursuant to the court order, where the judicial management was, the initial directions were set forth. So it was both statutory and pursuant to court order.
If leave is granted, doesn't the applicant have to file fresh proceedings?
My lady, I note your reference to the term fresh. As I said, I agree that proceedings would have to be initiated if leave was granted. But in the similar line to that as discussed in Hunt, our position is, even although it may have been viewed as a mark in the sand, the courts have normally viewed such proceedings to be interlocutory.
Mr. Allain, I was going to ask, can both actions be initiated at the same time? The action for leave and the action for enforcement of the foreign judgment?
It is not the practice, my lord. I would say no. I do not believe that they can be initiated at the same time.
That seems to be what occurred here.
Sorry, my lord.
That seems to have been what occurred in this instance. If you look at the judgment of Cornelius J.
Give me a moment, my lord. I'm accessing the
Yeah, so while you're accessing that, there's another way of looking at this. So, from your point of view then, the initial action should be for the lifting of the stay. Would that not need to have some basis, some reason as to why that request or that application was being made? And surely in this case, it was the fact that there was this foreign judgment which was to be enforced against the company.
I agree, my lord.
Yes, I'm just wondering about how we divide these matters up into very technical silos, compartments. You know, it seems to me that one is really related to the other. The reason that a stay is required, the reason why the lifting of the stay is required is because there is a judgment to be enforced. And it seems to me that both lines of inquiry were conflated in the litigation we have witnessed so far. Certainly at the first instance level. Yes.
I would suggest that even if out, and I take your point as to maybe the technical distinctions, but I would suggest that on those legal technical distinctions, there's no ability to conflate the actual proceedings with your application to lift the stay. Yes, you are correct that facts are required to support your application, and it would be open to the applicant to put forward the fact that there is a judgment in another jurisdiction and the nature, or even if he's arguing substantively that the documents that I have prepared for the actual filing prove the substance of the facts necessary for the application to lift. But I don't know that on the basis of the prohibition on filing a matter that you can in any way say that you can file at the same time as you apply to lift.
Right, so Mr. Alain, if I get it straight, you're saying there are two separate matters. First of all, you've got to establish this foreign debt by getting it recognized by way of a summary judgment. And only when you've got that judgment debt in Barbados can you then seek to enforce that judgment debt in Barbados. And it would appear, looking at pages 48 of the record, that what the claimant initially sought was just liberty to begin proceedings against the defendant to recover this particular sum of $1 million odd. And then on page 51, there was the draft order that was looked for and sought, that the claimants be at liberty to begin proceedings against the defendant to recover the sum of such and such dollars. And the order is made pursuant to a judgment obtained by the claimants in the Eastern Caribbean Supreme Court, claim such and such, dated such and such. So it appears it started off as recognizing before you can enforce anything, you must first of all establish you've got an effective debt. And in the case of a foreign judgment debt, you've got to take this summary procedure. So what was sought was leave to commence the summary procedure. And then, assuming that went ahead in straightforward fashion, as normally is the case, then you'd be able to say, here we are, I've got this judgment debt for the liquidator or for the judicial manager to deal with, and that is a separate issue. Would that be how you see it?
My lord, I would suggest that what occurred here was an application for leave to file proceedings.
Precisely.
And it was not after an establishment within Barbados of the judgment debt. Certainly, the judge at first instance would have dealt with it in the context of someone seeking permission because of the existing stay proceedings. And as such, there was a need to first lift that before she could proceed.
So that it wasn't so much as a stay of existing proceedings that was being challenged, it was an application to commence proceedings. Now, the point to get back to this issue of the preliminary issue, if an action had been in existence before the judicial management was initiated, in order for that action to continue, the claimant would have had to apply for the automatic statutory stay to be removed. In that circumstance, that application might rightly be considered interlocutory. But where the action has not yet commenced, but it is felt that Section 57 of the Insurance Act bars you from even commencing an action without the leave of the court, then I don't quite understand how an application to get permission to commence such an action is being regarded as interlocutory. Inter means between, among. It is among what? It is a separate res. It is seeking to get the court's permission to commence a fresh action. Isn't that the case?
My Lord, it is seeking permission to bring proceedings, and that is in line with the directions of the court, which stated that the stay related to the ability to bring or continue a claim or proceedings against the defendant.
Or to commence a claim. They're not continuing it. One did not yet begin when this action was filed.
Or continue. So I am agreeing with you, my Lord, that it related to both continuing and initiating, as you have indicated.
And I want you to respond to the notion that if it is an instance where an action had not yet been initiated, then the idea that this can be interlocutory is a little awkward, to put it mildly, because it is not in the middle of any particular action. It is to seek permission to commence a new action.
My Lord, I agree with your reference to the fact of it being awkward. But as I said, we took direction and an indication from the case of Hunt and Allied Bakeries.
Yeah, but that's a whole different circumstance. That is where there was a single action, and a stay in that action was sought to be removed so that the same action could be proceeded with. So it's different. But I don't want to prejudice your mind. So you say that it is interlocutory because it's an application for the removal of a stay. That's your argument.
And my argument, my Lord, is that it does not bring the substantial matters to a conclusion.
What is the substantial matter?
And the substantial matter in this case would be the enforcement application by the applicant at that time.
Has that matter commenced?
I thought they admitted it was not for enforcement, but just to commence proceedings, to get the foreign judgment recognized. Wasn't seeking to get any debt enforced.
My Lord, I take your point in terms of the distinction between commencing and continuing. And I also agree that this was a first step in terms of proceeding at a later date to get a judgment enforced. And as you said, there was first a need to get leave to initiate. to the extent that we were seeking and dealing with an issue of initiating a first step between the parties, and that further steps would be taken for the substantive claim, we consider this to be interlocutory, to the extent it did not deal with the substance.
Yes.
But even if you are correct, Mr. Aline, on that point, would you be resisting the opportunity for the plaintiffs to have their day in court in relation to their application? Because this is a point which raises a matter of some interest. Obviously, I think you have conceded that people were misled about the interlocutory nature of the matter, so that in any event, you would concede the court has jurisdiction to grant leave. Are you resisting the ability of the appellants to move forward with their case before the court?
My Lord, certainly I do agree, as I've indicated, that the court does have the power to grant leave in these circumstances. And if the court is so minded as to the substance of this application in terms of judicial value and benefit to the public, I would not be resisting the opportunity for them to be.
Well, it's not just that. There was a certificate of compliance given, wasn't there, on the basis it was an as-of-right case, and I believe Mr. Coleman didn't object to that at the time. And so this is why matters were led to go very far before, in fact, this particular point was taken. So that if there's any problem over time, an extension of time should be granted anyhow.
My Lord, I be guided by you.
Yes. Okay, thank you. Is there anything else on that preliminary point?
Well, no, my Lord. I would not take up your time for the preliminary point.
Yes. Okay. Ms. James.
Thank you, Your Honor. Your Honor, so may I go ahead now with my substantive submissions? Or
Yes, please proceed with your substantive submissions.
Yeah. Your Honor, I don't know if I need to go through the full background of this matter. I see now that I've printed out these documents just how long my submissions are, and I'm not sure if the court needs me to go through the details of the background.
We know the background.
But
We have a fair idea of the background. Yes, we know the background.
Thank you, sir. So where I would like to start, therefore, is with respect to our grounds of appeal and why we felt it necessary to bring this appeal. I would like to refer the court to page 8 of my submissions, or page 789 in the CCJ index.
789?
789, which is page 8 of my submissions with respect to the notice of appeal.
Yes.
Your Honors, what the Court of Appeal decided in its December 6, 2017 decision are as follows. The first thing the Court of Appeal decided was that the case Re-Atlantic Computer Systems case, which is at page 935 in the CCJ index, it decided that this was one of the leading cases with respect to judicial management and how these kinds of matters should go. We did not disagree with that. I think we agreed that there were quite a few relevant principles that could be applied. But what the Court of Appeal went on to do is to not apply all of the principles in that case, and we thought that that was a mistake. because we thought that if it had applied these principles and that at least on a common sense level, that it would allow the court to understand why leave should be allowed. What they decided, and if I go to page 9 of my submissions, they said that the Re-Atlantic case only referred to what is termed as proprietary claims as opposed to monetary claims. Now, in the Re-Atlantic case, they describe, they differentiate between proprietary and monetary claims as a proprietary claim being when you are going after the company's property. So if you are a claimant going after a company, you want the company's, you're going after your
own property.
A proprietary claim, your own property, yes. And if you're going after the company's property, it's a monetary claim. And the Court of Appeal thought, or they, in their minds, we are going after property of the company, which makes it a monetary claim. And based on the language in Re-Atlantic, Re-Atlantic does not apply to monetary claims. And their position was that they therefore cannot use Re-Atlantic principles because this is a strictly monetary claim.
But Ms. James, before we go further into this, the Atlantic case, of course, was one where you have the equivalent of a sort of landlord renting property out, trying to enforce property rights. So you can forfeit leases of cars or computers or land or whatever. So we're concerned with enforcement of particular debts at that stage. However, have we actually got to that stage yet? Surely we're at this preliminary stage that we mentioned 10 or 15 minutes ago, that the issue is there a debt that's due or not? Where you've got foreign debts, you've got to come to Barbados to get them recognized properly and take this summary procedure so that it's straightforward because there's a clear admitted debt in Dominica, and so you get summary judgment for the amount of that debt. And that's what you file for, to be able to commence proceedings to establish the debt. Only after that debt has been established do you get to the position of having to go to the judicial manager or liquidator or whoever, in this case the judicial manager, and say, right, this is the amount of my debt that I'm proving for. Or in the case of the judicial manager, this is the amount of my debt that I'm claiming, and I have a special case. I would like to put forward a claim, because obviously the onus is on you. But we haven't really got to that stage yet, have we? Your application just wants to liberty to begin proceedings to establish this debt. Your draft order was to establish that. So we're really at this preliminary stage still.
Yes, sir. So the reason that we refer to Re-Atlantic, Your Honor, what you've done is preemptively a bit, but I appreciate the question. So our position is, number one, that we have a judgment. And I was going to come to the issue that the Court of Appeal did not think that that was important because of Re-Atlantic. They did not think that it was important to rely on the fact that we have a judgment as a special reason for the state to be lifted, because they thought any principles in Re-Atlantic did not apply to default judgments. So our position, our starting position is, these people deserve special leave for the state to be lifted because they have a judgment. It's res judicata. They are entitled to this. So we just need to get over the hurdle of this statute that says we need, and an order that says we need leave to proceed. And that makes them the exceptional candidates that are required, that are entitled to leave. But the Court of Appeal, in applying Re-Atlantic, and we say wrongly, decided that the judgment didn't matter because it was a monetary claim. And what we say is that the Court of Appeal also referred to and relied on a case called AES Barry, which is found at page 974 in the court's index. And the case, if I may, right, and that is another Court of Appeal case out of England that was referred to and relied on in the Court of Appeal's judgment. And that case also had to do with a claim for a monetary, it was a monetary claim. And what they said in that case was, the Re-Atlantic principles can apply into monetary cases, even though it's done so in exceptional circumstances. And the court, I'm sorry, is the court having problems finding the?
Is it at 974?
974. Am I correct? Reatlantic, 974 in the court schedule. Oh, when I
That's
filed
your
these
reference to the case. That's not the
yes,
case itself.
I went according to different references, yes. So when I got the bundle together, I realized that it can be found earlier in the index. Because it was filed sometime, I think, the one I'm referring to at 974
Okay, yes.
would have been filed after. Have you found it?
Yeah.
Yeah, it was filed more recently.
Yes, okay, this is the case itself. AES Barry Limited.
AES Barry Limited, yes. So that case was referred to and relied on in the Court of Appeal. And that case said, when it comes to the question of lifting a stay, you can refer to the principles in Reatlantic, which are very good common sense principles. But you do that in exceptional circumstances when it comes to monetary claims. But regardless, you can apply it to monetary claims. And they went on then to apply this Reatlantic principle to say when a person may or may not have a leave lifted. So what we say is that when the Court of Appeal chose to disregard everything in Reatlantic, which starts off, the starting point in Reatlantic is, do you have a good prima facie case? Do you have a good arguable case? We say we do because we have a judgment. And that is something that is supported, that principle is supported by several other authorities that I will refer the court to if the court is so minded to hear me on it. So we are saying when the Court of Appeal disregarded Reatlantic, that caused it not to focus on the most important thing, which is that we have a judgment.
Can you clarify, counsel, something for me? Is there a conflict between Reatlantic and AES Barry? Because when you quoted from Reatlantic earlier, I thought you were saying that by virtue of having this foreign judgment, you have a right to proceed.
Yes, sir.
Whereas when you quoted from AES Barry, you said that in exceptional cases only, you have the right to proceed. So how do you reconcile those two approaches?
Because having a judgment is an exceptional circumstance, and that is supported by several cases that we've referred to, cases that were won against this very same judicial manager. For example, the case Hotak coming out of, it's Marlon and Hotak Limited versus Marlon and Alice Hotak versus British American Insurance Company Limited. That is a case coming out of Antigua. It was against a subsidiary of CLICO, where they found that having a judgment was a good arguable claim. And in that case, it was actually stated that you start at the part that you have a judgment, and it says having the judgment, if there was no judicial management and if there was no stay, would mean that you are entitled to this money. And therefore, what the court did was put the onus on the judicial manager to tell it, to give me an exceptional reason why these people shouldn't get their money. And that court found that being under judicial management was not an exceptional reason. Because, and they refer to other issues as well.
So is the time at which you get the judgment important?
Yes, we say the time when you get the judgment is important. Because in this case, we got the judgment before the court, they went under judicial management. So that existed before. We're not bringing proceedings.
But with respect, you haven't got the judgment yet. You had a foreign judgment, but it doesn't become a Barbados judgment that can be enforced in Barbados until you get leave to file these proceedings by way of getting summary judgment. And I think this is one of the problems, that you have to do that first, but then even if you succeed in that, so you get a judgment in Barbados, you're still only an unsecured creditor, and you have to face up to whether or not you can enforce it at that stage. So I think one of the problems that we have with the High Court and the Court of Appeal is getting confused between commencing proceedings, filing proceedings, and enforcing a judgment. We haven't got to the stage where there's any judgment to enforce yet. The case that helps perhaps bring this out is the South Coast Construction Limited and Iverson Road Limited case, 2017, England and Wales High Court 61, and it's the Technology and Construction Court, where the senior judge, Mr. Justice Coulson, now Lord Justice Coulson, was dealing with a situation similar to the one with regard to foreign debts, but it was in the case of the construction industry. In order, where there's big construction going on, for payments to be made promptly, an adjudicator can say there's so much due, but you can't enforce that adjudication until you go to the court and get leave to enforce that adjudication as a debt. And he held that even if there was a moratorium, you were allowed to go ahead with that procedure to establish whatever the amount of the debt was. But all that did then was, even armed with a judgment in its favour, if that's what the claimant gets, the claimant would still only be an unsecured creditor. Its status as a creditor would not be enhanced by any judgment. So no one's been affected at the stage of getting a foreign judgment debt recognised or an adjudicator's amount of sum in a construction contract recognised. So one allows that to go ahead, and now you establish the amount due on a liquidation or in a judicial management situation. But at that stage, you get into enforcement. And it seems to me the Court of Appeal was jumping the gun by looking ahead to enforcement. You haven't got a judgment debt yet, and that's why ordinarily you let matters proceed and you work out whatever the judgment debt is. So I think in this A.S. Berry case involving, was that one of the South Korean liquidation, you were still allowed to go ahead with the commercial court proceedings to establish how much was due, so that you could then prove for that in the liquidation. So it's normally reasonably straightforward to say, well, you've got these proceedings, you can go ahead and sort out whatever your debt is, but then you come to the problem of enforcement at that stage. But we don't run the two together, which seems to be what the Court of Appeal has been doing.
Well, yes, I understand that. I think what the question with A.S. Barry, because in A.S. Barry, the claimants were actually unsuccessful on the basis that there was a plan by the judicial manager. And I do take the point of the court with respect to the foreign judgment and having to bring proceedings to establish the foreign judgment and then go forward to enforcement proceedings. We take the point of the court. But with respect to the question of A.S. Barry and how it compares to Re-Atlantic and to the situation at hand, in A.S. Barry, what they looked at was a creditor who had not had any determination as to his rights. So he was just a person looking to start fresh proceedings. He didn't even have a default judgment like our appellants here. And what the court decided in that case, applying the Re-Atlantic principles and applying the exceptional that you have to have the exceptional circumstance to allow leave. It denied leave on the basis that there was a plan from the judicial manager that was in an advanced stage to deal with people who could be potential creditors. Part of that plan was to set up a special court to deal with any potential claims against the company. And in fact, the court in that case found that the claimant there and the creditor there was in approval of this plan. And so the court didn't feel that there was any reason to allow this man or these creditors or those claimants to go ahead with proceedings, to bring proceedings against the company, because the company had a system set up that was reasonably advanced, that was before the court, that the court could examine, that addressed their claim. So this is where I saw the major distinction between A.S. Barry and our case here, because what the Court of Appeal said in this case is that the judicial manager has a plan that has been approved by the High Court in Barbados, and that plan will address the claimant, the appellant's claim. This was decided that this was a major issue in the judgment, to say, look, there is a plan, it's going to address your claim, so there is no need for you to be here. We don't need to give you anything else. But the problem is that, unlike the case in A.S. Barry, there was literally no plan placed before the court. Now, when we went before the High Court in this matter, the respondent had produced a proposed plan, and that can be found in the affidavit of Mr. Patrick Toppin.
What page
and that
is that?
affidavit is found at page 28, sorry, at page 20, page 98. Page 98 of the Court of Appeals Index. And when Mr. Coppin presented that plan to the court, both myself and the judge were able to look at the plan, and I made certain submissions. If you look at the notes of proceedings, you will see that I made certain submissions saying, this plan has no funding, this plan has not been approved, and there are a host of issues with the plan. And one of the questions that the judge would have put to counsel for the respondent is, how soon will this plan be ready? How soon will it be ready to be implemented? And in my submissions, I don't think that counsel was able to answer that sufficiently, because in the plan itself, it said it had not been approved and it was waiting for funding.
So from what you say, it sounds that it was not so much a plan as much as ideas that can, or proposals for a plan.
Yes, exactly, Your Honor. It was a proposal for a plan.
This is nothing that could be implemented.
Exactly. And the reason we say Re-Atlantic and AES Barry cases are important, and also the other cases before this court, is there was an emphasis on the judicial manager having a plan that was comprehensive, so that a court could say, we understand that you, the appellant, wants to leave, but here's a plan that addresses your claim. And in AES Barry, they were able to do that, and leave was denied. But in Re-Atlantic, you see that the court said in that case that the judicial management had been in existence for 3 months, and within that time it was clouded in uncertainty, and therefore there was no plan.
Just as a matter of interest, Ms. James, that affidavit was filed in 2013. Have those proposals set out in what was to be a plan been realized?
Yes, no, sir. So what happened is that when
My Lord Ramon Allen here, just on a point of order and for your information, the plan has been given court sanction, and implementation of that plan has been initiated. Most importantly, for the purposes, I believe, of this application, is that one aspect of the plan was a determination of a proportion of existing assets for the benefit of policyholders arising out of the Eastern Caribbean Register. So a specific portion of assets has been set aside for Eastern Caribbean policyholders under a plan issued and approved by the court.
When? When was that done, Mr. Allen?
That order was given in December 2015, my Lord, and as I said, the implementation is ongoing.
Yes. So, Your Honor, so this is exactly what happened in the Court of Appeal. What happened in the Court of Appeal is that Mr. Leonard Counsel for the respondents said this exact same thing. A plan has been implemented, but the plan has not been put before the court, unlike in the case of AES Barry. Now,
excuse me, Lord.
Just a minute, Mr. Allen, we're not interrogating that issue now, and maybe I should not have opened that Pandora's box, but this is peripheral to the issues that concern us, I think.
Yeah.
Right. But Your Honor, if I may, with respect, from our perspective, and based on what the case law is saying, and all of the case law that we are relying on, at least the majority of it that the appellants are relying on, the question of a plan is very important, because the courts are saying that they have a right to look and see, and you've seen it in both the Atlantic and AES Barry, they've actually studied the plans that were put before the court to say this is how it's going to affect X, Y, and Z person, and bearing in mind that what the case law is saying and what has been said in the Atlantic, and if anybody has to look up just a rudimentary search, let's say in Halsbury laws, how long judicial management is supposed to last for, typically it lasts for 3 months. And if the court likes, I can refer the court to that section in Halsbury laws. But
yes, proceed.
But and so in the case of Re-Atlantic, it was consistent with this idea of 3 months. And what we have in this case, certainly when you look at the order the order that created this judicial management is in the same affidavit of Mr. Patrick Topping. You will see that there is no limit on how long this judicial management can go for. And when the court has the chance to study Re-Atlantic, you will see that it says very specifically, and in fact, anywhere you read about judicial management, it's supposed to be a temporary interim regime. And after a certain period, a certain short period, it becomes untenable with respect to the company's creditors for it to continue under judicial management. And at a certain point, the judicial manager, as an officer of the court, is supposed to address claims and pay claims, because it is wrong to have a person out of their judgment. And I understand the court says that technically there isn't a judgment, at least in Barbados yet. But we know they have a default judgment in Dominica. And it is wrong for a person to have that judgment and not be able to collect on it for an indefinite period. It's now 8 years since this company has been under judicial management, and 9 since they got their judgment in Dominica.
But Ms. James, this is relevant if you're seeking to enforce the judgment. But we haven't got to that stage yet. We haven't even got a recognized judgment debt. That's what we have to establish first of all. So why are we here today talking about enforcing the debt against the judicial manager?
Because it's relevant with respect to lifting the stay. That's what the case law is saying. And that's why we were referring to the Atlantic. So to remove the stay, so it's not with respect to just enforcement. Because Re-Atlantic and AES Barry, all of these cases are talking about the principles for removing a stay. So you see, when we look at it that way, that's why we say the Court of Appeal made a mistake in not considering this important point and the question of not having a plan and the length of time of the judicial management. Because what the case law is saying is that when it comes to removing a stay, separate to enforcement, just removing a stay, you have to look at these principles. You have to look at how long judicial management has been enforced, how long it will be how long it will continue. You look at what plans there are. You look at the conduct of the parties, and you look at the balance of something the Re-Atlantic people call the balance of legitimate interests. Now, we've referred to cases that follow these principles, whether with specific reference to Re-Atlantic or not. These are the principles that they follow. So that is why when the Court of Appeal said this is just a monetary judgment, it doesn't matter, and they didn't look at the conduct of the parties, they didn't look at the fact that there wasn't a plan, they didn't look at all of these issues that I've just raised, it was an egregious error in law.
So you're saying that, just a minute, you're saying that a relevant circumstance in determining whether or not the prohibition against commencing proceedings should be removed is whether the Johns, after 8 or 9 years, are any nearer to seeing a realization of the plan which the judicial manager should be putting in place.
Yes, exactly, sir. That's exactly what the case law is saying, and the case law that the Court of Appeal themselves found was the leading case on it.
Can you now more concretely say what is the principle, or what are the principles the court has to apply in order to answer the question whether leave should be given in this situation?
Yes.
Because you're referring to cases, but I want to know concretely from you, what is this principle? Because I hear you saying different things. You have to look at how long this thing is taking, but you're also saying, well, as soon as you have a judgment, even if it's a foreign judgment, if you have a judgment before this judicial management entered into force, that already as such is enough, or is that not what you're saying? Or do we have to look at that is one element, but there are other factors? I would like to hear exactly what it is that the court should do in order to solve this problem.
Ms. James, if I may pick up from there, you referred to Re-Atlantic, and Re-Atlantic speaks of a balancing exercise of the factors that my brother just asked you to address us on. So if you would address us on those factors that we should take into account, and let us know how we should balance the interests of these parties.
Yes. Okay, so so the principles are, besides what I've just said about whether they have a plan and the length of time of the judicial management, the principles are legitimate interest, balance of legitimate interest. This really is with respect to who suffers more in the grant of leave. Is it going to be or in not granting leave? You compare the position of the company and the position of the appellants. The appellants being creditors of the company. So what the case law says is that you have to say, is the company going to suffer by allowing this leave? Is something about the company going to be jeopardized? We are saying that the appellants, are in a position where, yes, they have a judgment, and there's a case from this very court that says, it's called Dipcon, it's referred to several times, the case of Dipcon. I suddenly have too many documents. But there's a case called Dipcon. I will come to the full name of the case. But it talks about, it says that where a person who holds a judgment is held, is not allowed to come into their monies, that could be ruinous for them. So that's number one, but I've dealt with that. But the other issue is the specific circumstances of these appellants. We have the first appellant, Mr. Octavius John. Mr. Octavius John, at the time that we brought these proceedings, had been diagnosed with cancer. And he had to get prostate cancer surgery. He received the surgery.
We know all of that. We know all of that story, Ms. James. I'm just concerned. We're getting a terrible feedback. Yeah, my concern is each of the policyholders whose monies have been frozen would have a hard luck story. His is a very, very tragic story. But I have no doubt that there are other policyholders who have, if not just as tragic, almost equally terrible stories about not having their funds. So I wonder how much store should be put in that peculiar circumstance of his, as distinct from more principled circumstances, such as the two that you have alluded to, namely that you already have a judgment, albeit a foreign judgment, but a judgment which is easily capable of being translated into a Barbados judgment. And secondly, according to you, you have not seen after 8 years any clear plan that will allow your clients to obtain even some of the funds which they had invested in this vehicle.
Right. Yes, and that is a correct understanding of what I'm saying, but I don't think we can ignore I'm not so comfortable, Your Honor, with the issue of the question of saying that many of CLICO's policyholders are suffering, and that is the position that the Court of Appeal took in saying that they are not that they are not special. One of the things that the judge of the High Court said is that if there's any other people suffering, they're not necessarily before me. These people are before me. These people have found that their suffering is so extreme that they have to come here. That's number one. But the other issue is that what the case law is saying, and there's another case besides the Atlantic which says this, but there's a case called Lane versus Cape Sea, which I refer to. It says that the judicial manager has, or the court has the power to give certain orders, whether it's this court or the court that does the enforcement proceedings, to say, look, if you are having problems as a company, you can give some money, give something. There are certain orders the court can make to address the issues of the appellants before it. Now, obviously, my clients want all of their money, the appellants want all of their money, but that the Court of Appeal had decided that nothing should happen. We say is egregious for any of these kinds of people and anybody who comes to the court in the position of the appellants who also have a judgment. So we are saying if you conflate the issue of the judgment and their hardships, that is not enough to say, oh well, thousands of people are suffering. And that's what the Court of Appeal said. They actually used the language. Thousands of people are suffering throughout the Caribbean. Why should we lift this day after 8 years? So that's what we have an issue. We think there's a human rights element to this that cannot be ignored. And specifically with these appellants who felt it important enough to take it to this stage. And so I don't think we could ignore that factor when we talk about the balancing the legitimate interest. So the other thing I would say in terms of what the court has to look at is the conduct of the parties. So what happened in this matter is that when the default judgment was obtained, sometime in October of 2010, the negotiations ensued. And what you will see in an affidavit of Mr. Octavius John, and that affidavit is, can I get the index? Just the index. The affidavit of Octavius John is found at page 2 of the court's, sorry, at page 1004 of the court's index. And what Mr. John says in that affidavit, and he said he exhibited letters to support what he was saying, is that the company now, before it was under judicial management, the company said, we are going to enter into a consent order with you. We will start paying you money from April of 2011. Remember, bear in mind the judgment was obtained in October of 2010. And so they said we can start paying you $75,000 cost and interest from April 2011. The appellant attorney wrote back and said, well, can you start paying us sooner? And what we would accept is less money if you can at least start paying us sooner, because April of 2011 is really far away. And they wrote back and said, no, we can only start from April of 2011. What happens in April of 2011, an application is made for the company to go under judicial management, and all proceedings are stayed. And what is interesting, is that the attorney for the John said in their letter, to prevent us going to bring enforcement proceedings against you, it would be helpful if you could start making these payments sooner. We would take less money. And they said, no, you don't worry about that. We will pay you from April of 2011, and if our circumstances change, we will get back to you. And they depended on that. The appellants depended on that. What we found since bringing these proceedings is that there's another case coming out, I think, of St. Vincent. Yes, and it's a case coming out of St. Vincent where the exact same promises were made to the appellants, to the claimants there, where they said, we will start paying you from April. The exact same thing. So we cannot say, I cannot say exactly why this was done, but I think it is I think that an inference can be drawn that this was something that was planned and deliberate. That somewhere somebody knew when they were going to go into judicial management. And to stave off enforcement proceedings, they got this pattern of behavior of telling at least these two people, we will pay you on your default judgment in April 2011, coincidentally going under the judicial management at this time. What Re-Atlantic and Social Security Board is the case that I have on here, a case called Marlon Hutak, is saying, is that the conduct of the judicial manager is relevant in these cases.
But I followed you up to that point, but was it the judicial manager whose conduct you are impugning?
Because, yes, Your Honor, because what the case of Marlon Hutak says, and also the Social Security Board case, is that when the judicial manager becomes aware of a default judgment or aware of some sort of duty that it has to an appellant or a claimant or to a claim in general, especially when it's a default judgment, you have a duty as the judicial manager to address it and to deal with it. You can come to the court and you can say, you can stay it or you can pay it. You can do something. The last thing you should do is to ignore it. And the case of the Social Security Board that I am referring to now.
But at the time of the consent order, there was no judicial manager, was there?
There was not a judicial manager at the time, but there's a judicial manager now who knows what was promised and who knows that there's a claim outstanding. And in that same document that I referred to from Mr. Patrick Toppin, you will see that in the order that's exhibited in there, the order says that the judicial manager is an officer of the court who has a right to rank claims and pay claims. He has a duty to do that. And if the court were to look at Section 57 of the Insurance Act, let me just be clear that I'm looking at the right.
You're saying that he has the discretion and the authority to look at what has been done in the past by the company and to right wrongs or to behave in such a way that creditors of the company, the policyholders, are dealt with in an appropriate way.
Yes, sir, absolutely. And Section 57(5)(b) of the Insurance Act, it says it also, which is what the judicial manager came under Section 57 of the Insurance Act. It says that the judicial manager or the court that appoints it it has a duty to investigate whether any policyholder is suffering a loss and to address the loss. That is the duty, and what is repeated over and over again in the Act and in the order that created this judicial manager. It says the judicial manager is an officer of the court. And what the case Marlon Hotak says is that in not addressing these judgments, not addressing those claimants who had default judgments in any way at all, was not in step with what is expected of an officer of the court, and they found that that conduct was bad and unacceptable. And it was part of the reason that leave was allowed against the same CLICO. The case Social Security Board is against CLICO. In that case, Your Honors, there was a contract for the sale of what was termed in that case as CLICO's most valuable asset. And bearing in mind that when you describe it as that, the most valuable asset, you see that in that case they were going after CLICO's assets. So we say that's a monetary claim against CLICO. And what CLICO did is that before and after judicial management, it kept promising that it was going to fulfill this contract. And then they decided not to, relying on the question of judicial management. So what happened is that the claimants in that case wanted to enforce the contract to sale of what they say is CLICO's most valuable asset. And CLICO said, you can't enforce it because I'm under judicial management. And what the court said in that case is that you kept promising to adhere to the terms of this contract. And even though, as was submitted by the judicial manager in that case, they said that we will lose $4.5 million on that sale. The court said, no, you promised. You kept making promises to pay these people. They were patient, they were understanding, and you repeatedly, both before and after, led them to believe that you would complete the sale, and you did not. And your conduct is so egregious that we cannot allow you not to fulfill your obligations. So we say that the conduct of this judicial manager is equally as egregious. And we also want to say that the case Social Security Board relied on the Real-Atlantic principles, which is where all of these matters are set out, the conduct of the parties, legitimate interests, whether there's a plan, length of judicial management. That case relied on all of those things and came to the conclusion, even where it was technically a monetary claim, that leave should be allowed in that case.
Yes, sir, Ms. James, I'm very sympathetic to the case you're making about enforcing a judgment debt, but we haven't got to that stage, and I think we've got to look at what exactly is the scope of Section 57, subsection 4 of the Insurance Act. What is the scope of the lifting of the stay that you're seeking? 57.4 ensures that once you've got this petition for judicial management presented, all actions and the execution of all writs, summonses and other processes against it shall by virtue of this section be stayed and shall not be proceeded with without the leave of the court being first obtained or unless the court otherwise directs. So you have brought this action that the claimants be at liberty to begin proceedings against the defendant so as to establish the foreign judgment debt is a Barbados debt. And if you establish that, you are then still left with Section 57.4, if we allow this action to proceed, you're still left under 57.4 with the fact that where a petition is presented, the execution of all writs, summonses and other processes against it shall by virtue of this section be stayed and can't be proceeded with without the consent of the court. So that if you get leave, then there's still, it seems to me, is the need to come and get the execution lifted. But getting the execution lifted is separate from the preliminary process of getting the action, the stay on the action lifted, so we can quickly establish what the debt is.
Yeah, okay, so, Your Honor, yes. So I think that I'm probably not coming across very clearly as to what exactly we're asking for. Now, the question of lifting the stay, we maintain that the stay is not something, the stay is something that can be lifted with leave of the court. And the court has a wide discretion, based on the case law that we are relying on, as to when it can decide to lift the stay and in what circumstances. And that is set out in the case 3 Atlantic, Lane versus Capsey, AES Barry. That there's a wide discretion as to what orders it can give. So the question of how whether you can enforce the judgment in Barbados, how and when and why you go for further enforcement orders, all of that can be established and decided by an order of this court or the order of a later court. All we're trying to establish right now, what we're after right now, is the removal of the stay so that we can bring certain proceedings. Now, there's a case called Lane versus Capsey that I'm relying on that actually speaks to that.
What case is that, Ms. James?
It's called Lane versus Capsey. I would say where it is in the... Lane versus Capsey, it is in... It's 174 and 172 of the bundle of the court's index.
Okay.
In my submissions, I refer to it in the exact stage, and I had intended to go through my submissions in a certain sequence. So it's very difficult to say exactly where in the judgment I'm referring to at this stage, but it's definitely in my submissions. And what that case says is that the claimants in that case had a judgment. And what they wanted to do was not just to enforce the judgment, but they had a judgment that said they had certain rights against the company, which in that case was under receivership. And they were asking for the stay to be lifted so that they could bring certain proceedings against them to enforce the rights that were established by their earlier default judgments. What the court said in that case is that it wasn't able to give them everything they were asking for on their application for leave, because there were a couple of things they wanted to do against the company to enforce the right that was established under the default judgment. So there were a couple of things that they were suggesting they wanted to do. What the court said in that case is, we will give you leave to do X, Y, Z, because that is within the rights of what you're asking for. Okay, you have at least the right to seek in some way or some form to enforce your rights.
But they had a real property right, a right of way, didn't they? It's not an unsecured debt.
Yes, they did have a real property right. We agree with that. But what we're saying is that within the question of the wide discretion of this court, we're asking the court to consider that it has the power to say that regardless of you needing to enforce, to seek to establish the judgment in Barbados, we are aware that you have a subsisting default judgment from Dominica, from the same company who also operates here, who is one of its main headquarters is here in Barbados. And on the overriding objective, and in all of the circumstances, the conduct of the parties, legitimate interests, and in the wide discretion of the court, we can give you leave to do X, Y, and Z.
No, but sorry, Miss James, what is X, Y, and Z? What exactly do you want us to do? But what precisely?
We would like
yes.
Yes, we are asking the court to lift the stay so we can register the judgment in Barbados, which we say is just procedural, and we say we will be successful at.
But to lift the stay to what extent? Is it just to lift the stay as to liberty to begin proceedings, or is it to lift the stay with regard to execution of a particular judgment debt, although it's not yet been established?
Well, we say the court has the power to allow us to do both. The court has the power to allow us to do both. That's what we're saying. But our application is to lift the stay to bring enforcement proceedings. Yes, that's our application. That's what we would like.
So you'd like to amend your application? Because at the moment you're just asking for liberty to bring proceedings, and which is straightforward. We can say, well, yes, there's no harm, establish it, because it does no harm. It's straightforward just to sort out what the debt is, but then you come to the key position that execution of all judgments is prevented without the leave of the court, and that's when you have particular difficulties, an unsecured creditor. And that is a separate proceeding, but you're trying to do two things at once. I sympathise. It'd be very nice to be able to do both at once, but we haven't yet got, I know it may seem a bit technical, we haven't yet got a fixed debt. That should be automatic, really, allowing that to go ahead, and we lift the stay for that purpose. So you then establish what the debt is, then you negotiate with the judicial manager, and hopefully, in the light of certain comments that may be made this morning, you might be inclined to get a satisfactory compromise, and then that would be an end of the matter. Otherwise, then you have to come and get a lifting of the stay on execution of judgments. But execution of judgments is a different thing from actually bringing the initial action you're looking for.
Right, so what the court is saying then is that it can only, it believes itself only capable of lifting the stay in terms of registering the judgment in Barbados. And then we would have to go through the process again of lifting the stay in terms of enforcement of the judgment?
No, but this is what I'm asking you. So you must tell us what is it that you wish, and we can decide whether we can grant it. So first you want the stay lifted. Yes. Secondly, you want the right to establish the debt in Barbados, the debt based on the Dominican judgment, either by registration of the judgment or by common law action. And then thirdly, you want to have the debt as established enforced against the company. Is that what you want?
Okay, my understanding of what should happen is that the stay is a stay against all proceedings, period. We expected, and you'll see what the High Court judge said, is that once the stay is lifted, I then have to file an application to seek to enforce the judgment, which actually I did do. I did file that application after she said that, because that was the basis upon which her, right. So my understanding of what was happening is that you lift the bar from me bringing any proceedings at all. And once that bar is lifted, it's just no longer in effect anywhere with regard to any further proceedings once it's in respect of this judgment. So in other words, if the bar is just to, and I will be guided by the court on this, but if the bar is just to lift proceedings to the extent that I get to register the judgment, and then I have to come back again to lift the bar again, I think that I'm not sure that that is
helpful.
As far, that's the limit of the court's power.
So that's what I'm saying. You want to lift the stay in a general sense. Specifically, you want the right to file the application to have the judgment enforced, and then you want the judgment to be enforced against the company. So there are basically two things you want, two substantive things you want, in addition to the general lifting of the stay. Or don't I understand you?
The general lifting of the stay means that it does not affect any further proceedings by these people.
Well, that is an ambiguous position to take, because obviously there are other people with different views about what that means. In other words, one view is that the lifting of the stay relates only to the competence to register the Dominican judgment in Barbados, and that you then have to have another bite of the cherry by coming back to the court to ask the court to then allow you to enforce that judgment against CLICO. I gather you want to do those two things together, or am I wrong?
Yes, sir.
Yeah.
Yes, we want to do those two things together.
And your original application didn't deal with those things. If you look at page 48 and 51, you were just concerned to be at liberty to begin proceedings. You didn't ask and to enforce any judgment debt that was thereby established.
No doubt.
Are you saying that there was a subsequent amendment to try and deal with that, or not?
Or is it that you thought that when we lifted the stay to commence proceedings, the lift would accomplish both things?
Everything. That's what I thought, that the lift will accomplish everything, will accomplish both things. That's the ultimate goal, is to be able to do both things.
But after the judgment of Justice Cornelius, Ms. James, you filed an amended application.
I did, yes.
Well, what was that amendment, and where can we find that?
I don't think I submitted that. I don't think we submitted the amended application. I don't
We
think that
have
was
not been
included in
able
the
to
bundle.
find it.
No, but
Yes,
I
we've
thought
I've not
I
included
saw
that in the
reference
bundle.
it being,
But you have it?
Not on me, because I think that the way I treated this was to allow the decision of the the decision of the High Court that I filed the amended application, but did not become a factor later on. And it almost as if it wasn't part, because it was completely separate proceedings is what it became. And so we didn't include it in the bundle because it just was never something that was factored in later on. And so I don't have it on me. But if memory serves, it was, I cannot even begin to speculate what that was exactly, because immediately after we were appealed against, and it just became completely separate proceedings that did not factor in at all. Because as the court has rightly surmised, and what I'm saying is that I took it to mean that once the stay is removed, it's just removed completely as with respect to this application, with what we're asking for today. And so I would have to apologize, because that's definitely my error.
Well, it's clear that
If it's not part of the record, do we have to ignore it then?
it's clear that you want to get your money, and that you want the court to clear the way, so that you can start all those procedures that are necessary to get to that point. Correct?
Yes,
And
that's what we want.
As far as I can see, the whole discussion in the Court of Appeal and also in the written submissions before us, the arguments that are used on both sides really go to the matter of whether CLICO in the end will have to pay or not. So maybe we're making the law a little bit too complicated here. I'm not sure.
And the other thing I would say, Your Honors, is that we did do submissions. If you look at the notes on proceedings, we did do independent submissions, both counsel, on what it means about registering the judgment, because that was asked of us by the court below about what the process was. The High Court judge asked us to do that, to make submissions on what the process was and how we would properly be able to enforce the judgment here. We did do submissions on those, and we did not include those in the bundle because, again, I don't think we really.
I think it's a standard method, is it not, with regard to foreign judgments? You just say there was this debt established in foreign proceedings, so I now just go for summary judgment under whatever the relevant order is, because there's no possible defence.
Exactly, because we treated this as procedural. I didn't think of it as a bar. Yeah, I didn't think of it as a bar to anything, really. I thought this is just the part of the process of doing something that cannot really be objected to.
Yeah, but it's a fundamental separate process, in order to get leave to go ahead with that or not. And if you get leave to go ahead with that, then clearly you've got your debt. But until you've got an established debt in Barbados, you can't start seeking to enforce it. Although you're wanting to try and run the two together on the basis that it's a bit of a technicality. And we all know it's most unlikely that there could be any objection to summary judgment being granted.
Well, Your Honors, I'm in the hands of the court on that one, because I really was prepared to deal with that question. I've said what I assumed, and I saw this as just a technicality. But I'm absolutely guided by the court on that. But bear in mind that
even if there was a defense to the application to enforce the Dominican judgment, I'm not sure what would be lost by the leave being a comprehensive leave, which gives you the right to proceed, because all that would mean is that you would fail at the first hurdle. Because is there a difficulty in establishing the debt based on the Dominican judgment? Then obviously you cannot enforce anything against the company because you'd have failed at the first hurdle. So it's implicit in the further stage of enforcement that you have established the summary judgment based on what you got in Dominica. So I really am at a loss to understand why is it that we have to run separate procedures for this action. It's either you succeed in establishing the judgment based on what happened in Dominica, or you don't. If you don't, or to the extent you don't, then you can't proceed against CLICO anyway. But if you have established it, then surely the leave should allow you to proceed against CLICO once you satisfy us that the test has been met.
Well, I'm guided by the court, whichever the court chooses. Gets us off the money.
Yes, we need to.
I'm guided.
Yes.
Yeah. Is there anything else you'd like to advance, Ms. James?
Your Honor, I think I've covered everything. May I just have a moment to just look quickly through my submissions just to be sure? I'm just quickly running through my submissions, Your Honor. Your Honor, I believe this is it. I don't think I have anything more to say except that I've said a whole lot in my submissions that were filed at this point, and the court, if I've left out anything, I'm sure it's in there. So thank you for hearing me on this, and I will give way to counsel.
Yes, thank you, Ms. Aline. Ms. James. Mr. Aline?
Yes, Lord. Having taken some guidance from the queries that I have heard posed to my friend, I would like to address a few issues that have been raised, maybe to explain the process in terms of how I shall choose to respond. Now, I believe this Justice Hayton would have reasonably inquired as to how the process was viewed, and I believe he was speaking to the normal idea of a bifurcation, where the issue of liberty to proceed is separate and distinct to any element of enforcement. And I understand the basis on which he has raised that query. As has been stated and discovered, if you take view of the Court of Appeal decision, the court took the point of view that it was dealing with ultimately an issue of enforcement, and as such, it went to the substantive issues that would affect a claimant's right to enforcement, hence the reliance on Re-Atlantic and AES Berry and the like. Ultimately, you can ask whether that was a conservation of judicial time to deal with it in that manner, because the issue of lifting the stay, ultimately, as my friend has indicated, was for her purpose of enforcement, and to the extent that you may give an order at a first instance, and then ultimately it fails on the second instance on the substantive review of the law of enforcement against a body in judicial management, the court may well have taken the point of view that it should deal with it holistically in terms of its decision. And I believe that is what informs the Court of Appeal decision. If you take reference...
Mr. Aline, I got the impression that you looked at it in the same way.
I did, my lord, and you are correct on that. I'm not suggesting that we dealt with it in any other manner.
Because if everybody had very clearly in mind that this was leave just to do this summary procedure, just to get the translate the Dominican judgment into a Barbadian judgment, you might not even have objected. But when it comes to the next step, which is where you have to pay, that's where the pain is.
Correct, my lord.
Yeah.
And if you make reference to the original application, I believe Justice Hayton would have referenced, but it reads that the claimants be at liberty to begin proceedings against the defendant to recover the sum of $1.4 million. And that was the exact wording of their application.
Yeah.
And as you have said, everyone proceeded thereafter on the basis that it was an application to lift the state to facilitate enforcement. So you would have seen, my lord, that hence the focus on an understanding of what are the criteria applied by Re-Atlantic and AES Berry. I differ from my friend, and I believe the question was asked as to the substantive considerations and what informs the balancing when the court is looking at an issue like that. And the comparison is not between a claimant and a company. The comparison and the balancing is between a claimant and all the other policyholders. And the question being whether it is right to give one particular policyholder a run ahead of all the other policyholders who are to be protected by the administration. That is the balancing that is to be addressed. Now, I also believe that my friend has misconstrued the learning of Re-Atlantic. It was not in any way limited to one type of claim. The justice were at pains to point out that they believed there was to be a distinction in the treatment of proprietary claims, that is where an applicant was basically seeking to deal with what is his property, and those claims where you were seeking to basically go after the company's general asset in furtherance of a monetary claim. And generally, it was accepted that if it was a monetary claim, and I believe that there is no argument that in the present situation this is a monetary claim, it would be very difficult to lift the stay. And generally, the rule will be that the stay would not be lifted because ultimately you would be given an unfair advantage to one policyholder in this situation.
You keep saying that, Mr. Alleyne, but who is the policyholder you're talking about?
I referenced the claimants in terms of policyholders.
But they're not, are they?
They are not policyholders, my lord. They are persons with a judgment established and as such will fall into the line of creditor.
And that puts them in a distinctly different category because they did have policies. They decided to surrender those policies and to be paid by the company. And of course, you know the history of the fact they had to go to litigation and so on. But it's not one policyholder being compared with other policyholders. These persons have decided to turn in their policy and to get the money due to them from the company. And they have judgment in their favor to that effect.
Well, my lord, as you would, as one of the justices would have indicated, the result is to place the applicants ultimately as unsecured creditors. And if the comparison is to be made between unsecured creditors and generally the interests of the policyholder, I would suggest that they are actually at a greater disadvantage in that, carrying that status than if they were a policyholder.
But they're not just any unsecured creditor, are they? Basically, they appreciated things were getting a little on the dodgy side. They were wiser than the other policyholders, so they took steps to try and get their money out as soon as possible. And they got a judgment, judgment in default, and then they got CLICO to agree by consent, accepting the judgment, to pay installments of $75,000, I think, starting at the end of a month, 3 or 4 months ahead. And just before you got to that stage, they went into judicial management, so nothing was obtained. But surely this puts these ex-policyholders in a better position than the ordinary policyholders who were not alert trying to protect their interests in any way.
Well, Lord, I would suggest that if you are to make that assessment as to whether they are in a better position, reference would have to be made to what is the status of the company under judicial management, and specifically what are the priorities of the judicial manager in making his determinations. The Insurance Act specifically indicates that his actions are to be guided by what is considered to be most advantageous to the policyholders as a general, and more importantly indicates that in that effort, the court has the right to negate any contracts and the like that existed between the company and third parties in an effort to safeguard the rights of the policyholders. The legislation ultimately places the policyholders in a better position than creditors. And I don't believe that is an unfair assessment in terms of the priorities that a judicial manager must take into consideration when making his determinations as to what is in the general advantageous interests of the policyholders as a whole. So that, yes, the question is based on a comparison of a creditor versus the policyholders which the administration or management is supposed to protect. And I think the considerations as set out in Re-Atlantic will still be pertinent. Certainly, the claim is a monetary one, and if we are looking at an issue of lifting a stay for execution, the relevant learning is to be found in that judgment. What my friend has sought to do is to utilize the considerations where it is a proprietary claim in advancement of her cause. And as such, she has gone through issues such as delay and the like, which Re-Atlantic set out were the considerations on a proprietary claim in justification of her client's position.
Are these, is this case unique in the sense that they have a judgment?
Registrar.
I'm sorry, we are getting a little feedback, my lord.
So is this a unique case in the sense that these brothers have a judgment and a consent order before the judicial management can enforce, or are there many more of these kind of cases?
My lord, there are others where there were agreements and some judgments before judicial management, so it is not unique. What I would say that it would be difficult to conceptualize that status as giving them some better right. I don't see how a judgment creditor, and let's assume it was not a policyholder, on the arguments that my friend would be making, it would suggest that any judgment creditor should take in preference, or possibly in preference, or to the disadvantage of the policyholders. And I don't believe that that was the intention.
But we're concerned with ex-policyholder. That's the key thing here, I think.
I understand that, my lord, but what I am saying is their status is that of a judgment creditor. And the fact that, and you have referenced certain specific circumstances as to how they attain that status as a judgment creditor. But I find it hard to sync that with the purpose of the Insurance Act on the matters of judicial management.
Well, Mr. Lee, one of the problems we have, is that I have not seen any submissions on the point you're now raising. I have not seen that there are other judgments given before judicial management was ordered. Is that anywhere in the files before us?
My lord, it's not on the files before us, and based on the nature of the pleadings as established, I did not consider it relevant as a relevant consideration.
No, but the other side is saying that their case is unique, and this is what distinguishes their case. One factor is that they had a judgment delivered in their favor before the order for judicial management. You don't think that if there are other cases of a similar nature that would be relevant for this litigation?
My lord, I did not consider the issue of starting or having a judgment before the reason of the unique. My friend, certainly the court below would have stressed what she considered the special circumstances of her client on the issue of their physical disposition and their physical suffering, and the nature at the time of their impecuniosity. These were the central focus of the arguments, hence why you would have seen the Court of Appeal speak to the issue that they did not believe that in the circumstances they could consider that her clients would have suffered more than any number of persons. Here you have a policyholder group of 30-something thousand who have been deprived of their funds and money. So that was the focus of the arguments that were laid before the Court of Appeal. And that was what was highlighted as being the special circumstances of the claimant.
Okay.
Mr. Allen, you spoke about the special greater disadvantage that these appellants may be having. I just wondered if they were considered policyholders, given what you said to us earlier about this new plan.
Yes.
Would they have received some or all of their monies under this plan?
It is under the plan, my lord. It is unlikely that they would have received all. It is most likely that they would have received some as a policyholder.
So some, excuse me, some policyholders have been paid.
Policyholders and my lord, I make a distinction between policyholders under the Barbados register and policyholders under the EC register. Policyholders under the EC register have not been paid. What has occurred is that a certain portion of the company's assets has been set aside for their benefit. My answer to your sister justice was on the basis that the assets are significantly less than the liabilities, which is the position for the whole company. No policyholder is receiving anything close to their full entitlement, and as such, it is likely that they would have received some portion of their entitlement as a policyholder.
Who was they when you said they?
The question was premised as to what would have been the position if they were a policyholder, sir. And I'm saying as an Eastern Caribbean policyholder, they would have received some portion of their entitlement.
So Eastern Caribbean policyholders have received some portion of their entitlement.
They have not received it, my lord. Monies have been set aside for their
Well,
benefit.
you're saying different things, because on the one hand, you say, well, the likelihood is that if they had been Eastern Caribbean policyholders, they would have received some of their monies. And then you say that, well, monies have been set aside for them, but they haven't been paid as yet, the Eastern Caribbean policyholders. Which of the two is it?
My lord,
or is it both?
My apologies. I am indicating that monies have been ring-fenced for the benefit of Eastern Caribbean policyholders, and that money will be paid to the benefit of Eastern Caribbean policyholders.
In 2056.
It has not been distributed as of yet.
Okay.
But the appellants here are not policyholders anymore.
Right, and I want to get precisely to that issue. You have said repeatedly that as judgment creditors or potential judgment creditors, they are worse off than policyholders. Why do you say that? Is there something in the statute that places them in a worse off position? Is there case law that says this?
My lord, the statute, and this is the Insurance Act which I reference, and I'm looking for the section, my lord, just bear with me.
Yes, sure.
My lord, if I may start, the first section which would be relevant in my consideration would be Section 61 of the Insurance Act. And this speaks to what the focus of the judicial manager should be in terms of his determination. The judicial manager shall conduct the management of the insurance company with the greatest economy compatible with efficiency, and as soon as practical, file with the court a report stating which of the following courses in the circumstances, in his opinion, most advantageous to the general interest of the policyholders of the company, and seeking an order accordingly. Now, my lord, that has occurred. A report has been filed and an order of court given on the basis that the plan was what was considered the most advantageous for the policyholders. As you would note from that section, the focus of the judicial manager is policyholders and not creditors. Later on,
just to be clear, some money has been put aside for the policyholders.
The Eastern Caribbean policyholders.
Eastern Caribbean policyholders. These two persons, these appellants, are not policyholders, so no money is put aside for them. Is that correct?
Correct, my lord.
Okay.
So, and that order that has been sanctioned by the court relates to the total assets of people.
But that will be subject to an order from this court, if it was to give such an order, allowing lifting the stay and allowing the applicants to proceed.
It would be subject to that order, my lord, on the basis, obviously, of this court's jurisdiction. What I would be concerned of would be that the court would be granting such an order without any reference to the circumstances of the plan that has been approved by the court and the judge. In other words, the impact of the order which you may contemplate in that regard would be made without reference to the considerations, the full considerations as to what would have informed the administration.
But that's CLICO's fault, isn't it? Not the applicant's fault. CLICO has the plan. It's onus on CLICO to put it forward as preventing the applicants getting anything. To the extent that CLICO hasn't done that, then that helps the applicants.
Has the plan been filed with us? Do we have a copy of that, of the plan?
My lord, you do not have a copy of that plan. The reason would have been these proceedings would have been initiated prior. We would have had to seek, and certainly, I will say I was not clear as to the process which the court would obtain. I considered that there was an interlocutory application, and that if there was going to be an issue of hearing the appeal, obviously with the court's power to determine all matters that would fall within your jurisdiction, I would have made an appropriate application for putting in further evidence on the normal considerations of further evidence.
No, just a minute. So you thought today's hearing was only going to address your preliminary objection?
No, I am saying originally, my lord, in terms of the course that we were dealing with, I knew we were dealing with the substantive hearing today, based on the court's indication in the filings. What I was unsure of and would have sought your guidance would have been ultimately if, as was done at the Court of Appeals occasion, my lord, a determination was made on the preliminary issue and then the court decided to hear the substantive matter. And I was unsure as to whether this court would be so inclined.
No, you see, my understanding, Mr. Allen, is that the appellant's claim is that we want this, I prefer to call it a prohibition rather than a stay. We want this prohibition removed, and among the bases for our desire to have it removed is that the plan, such as it is either not catering to our needs, or it is one which is taken a long time to be operationalized. In other words, an interrogation of that plan and of its effectiveness, of its implementation, is part and parcel of the appellant's case that I am in a circumstance where I need for this prohibition to be removed.
I mean, the issue of confidentiality wouldn't really apply to us, clearly. But I'm asking in general terms, are there issues of confidentiality surrounding the plan, CLICO plan?
My lord, we have taken that precaution in the proceedings, but I agree with you that I don't believe that they would apply to this court, certainly if it considered it relevant for the consideration. But that precaution has been taken throughout the proceedings and in relation to any third parties dealing with the matter. What I was saying, my lord, was that if the consideration was of the nature that you had previously described, in other words, it would be subject to the plan would be subject to any order given by this court in relation possibly to a procedure going forward, a settlement and enforcement. I would think it would be prudent that this court would want to be versed with the nature of the plan.
Is the plan a public document?
It is public to the extent that it was filed in court proceedings, my lord, and that the court's order was filed in the court proceedings, and obviously the file is subject to inspection and the like. So I would say yes, it is a public document.
Is there any regular judicial supervision to the judicial manager?
Yes.
Sorry, my lord.
Is there any regular supervision from the court, the High Court, in this judicial management?
Yes, my lord. The judicial manager is an officer of the court in response to the justice having conduct of the matter. He files reports to that justice in terms of the proceedings, takes directions in relation to any of the actions he may wish to implement. Where there is any doubt or concern, he has applied to the justice for directions in the matter. So there is an active judicial supervision of the judicial manager.
I want to go back to the issue about the comparative status as between policyholders and a creditor who has obtained a judgment, albeit one in Dominica. And when we were discussing that, you cited Section 61, and a particular provision that spoke to the judicial manager's responsibility to, I can't remember exactly how it was framed, but it referenced the policyholders.
Most advantageous to the policyholders.
Yes, well, it referenced specifically the policyholders. Now, to the extent that it does not seem to reference creditors, you say that that means that they are in a worse position. But it could also mean that courts should look out for their interests, given that certainly the section that you quoted does not seem to reference at all how their interests are to be catered for.
My lord, just one other section may be relevant to this consideration, and that is at 62.2.
5.2?
Sorry, 62.2, subsection 2 of the Act. The order of the court shall be binding on all persons and shall have effect notwithstanding anything in the instruments constituting the company or the articles or other rules of the company or in any contract. And the relevance of Section 61, which I quoted to you previously, and this one, I certainly respect the court as a protector of litigant rights, but I also recognize that the court is always.
Yes, go ahead.
Sorry, my lord, I didn't see you were still reading.
No, you can go ahead, please, Mr. Ali.
Yes. The court is also obviously going to be guided by the statute and what it would.
The order of the court. Give them the powers. Page 111.
Okay. Yeah, sorry, go ahead.
Yeah. The court would also be guided by what it would consider to be the reasonable intention of Parliament in terms as disclosed by the statute. Obviously, the reference to the sections which have indicated and the nature of judicial management in matters where you are dealing with an indiscreet insurance company, I would say that the legislation makes it clear that the interest of the policyholders is paramount. And that, to me, would be reflecting Parliament's intention to protect policyholders at all costs. It certainly would have been quite simple for some indication as to how creditors, be they secured or otherwise, to be dealt with in terms, and that is the case in many pieces of legislation. But with the sections which I have quoted to you, I think.
William Chandler sets it all out.
Another relevant document must surely be the charge that is given to the judicial manager by the judge, the directions that have been given to the judicial manager. Yeah. Would you agree?
Page 106 of the record, Justice Chandler sets out what the order is and what the powers are of the judicial manager.
My lord, let me access the document just a second.
That's it there. So just keep looking at the next page here. Keep looking at 106.
106.
You can take into 109.
Yes, my lord, that is the directions. That is the directions order.
Right, and at Q. Sorry, at QR. You see the R.
To rank, manage?
Yes, to rank, manage, adjust, and pay claims against the company. So that is where these appellants will fall. And it then goes on, and or its policyholders. So it speaks to claimants in the same breath as it speaks to policyholders, certainly in that particular paragraph.
It does, my lord. And I would say that the directions order is definitely pertinent, but certainly would be read in conjunction and guided by the legislation. I don't know that in any way would override any intention of Parliament as reflected by the legislation that has been passed.
Yes.
And certainly the full tenor of the legislation is that the policyholders' protection is paramount. That is
you keep saying paramount, but paramount has a relative connotation, and where the legislation appears, I mean, I haven't studied it, but from what you've read, where it appears to reference policyholders, it is not in relation to other people. It is simply referencing policyholders. You're dealing with an insurance company, so prima facie, the persons who the insurance company has to respond to are policyholders. But does that mean that the interests of other claimants are simply to be ignored or relegated to a lesser position, even if they have reasons to press their case that are more pressing than policyholders?
My Lord, that section that I referenced, yes, does reference policyholders, but it is also tied to the judicial manager's plan for the dissolution, winding up, settlement of the issue. And basically, it is indicating that that plan is going to be guided primarily by policyholder interests. I am not suggesting that any other third party is not to be considered. But as you will find in any receivership type proceeding, a receiver, judicial manager, administrator will take decisions relating to third party claim that serve the final interest of his obligations and jurisdiction.
In other words, the primary interests to be concerned with are those of the policyholders.
And why is that? Because they all trusted their money to CLICO, and they need to have it back, or at least as much as they can get back. And that is exactly the same situation for those who were former policyholders, in this case, the brothers John. They trusted their money to CLICO, and they stepped out, and they were thinking, okay, we're getting our money back. And they even got a judgment and a consent order. That's the only difference now between them and the other policyholders that didn't take those steps. But they all gave their money to CLICO, and they are entitled to get it back as much as possible, of course. I don't see, there's clearly a difference between the John brothers as former policyholders wanting their money back, and a caterer who catered for a party for CLICO or any other kind of creditor. So it would seem to me that there's no good reason to make any distinction between the appellants and policyholders, current policyholders.
Except you say that
well, Lord,
we're guided by the legislative language. I think that's your response, is it?
Sorry, could you repeat that, my Lord?
I was anticipating that you would say that we are guided by the legislative language.
My Lord, you are correct. Part of my issue and concern is, when do we take the technical point? I would have accepted very readily that by the filing of the claim and the judgment and the like, the legal nature of the applicant obviously changed. It was suggested that might have been a prudent move to their benefit, possibly. What I will say is that the legislative language is clear. I don't believe there's any doubt as to the legislative language. And I understand the concern that the court may put forward in relation to, well, what is the justice of an applicant in this situation who is a former policyholder being disadvantaged? And I would swing that on its head and ask, my Lord, well, what is the justice that the former policyholder should be in any better position than the policyholders who took it, and are now in a position? So ultimately, it would be that the court will be left with a balancing situation where there is a plan that has been approved by the court pursuant to the legislation. The plan was made pursuant to the directive that the primary concern will be the policyholders. It is an entity that was substantially in deficit and insolvent in terms of its obligations vis-a-vis its liability. Yeah. And in the circumstances, there is no Eastern Caribbean policyholder who will be in a position to receive any amount near to their entitlement.
Ms. Allen, on that note, what would the Eastern Caribbean policyholders be receiving? How much on the dollar?
My Lord, I do not wish to give you the impression that I have an exact answer to that. the best information that I have would be in the region of 25 cents.
And if these people, these appellants were paid, have you looked at the impact on that 25 cent piece that the EC policyholders will be paid? Will there be an impact if this judgment were enforced?
Well, ma'am,
Or is it that the assets are so much more than that there would not be an impact?
Well, ma'am, I can clearly state that the assets we are discussing is in the region of $31 million. So if you are talking about 1.4, 1.5, when you add 1.5 million, you're talking about 1.5 million out of 31. So in the context of a few thousand Eastern Caribbean policyholders, ma'am, I would say that that is a significant impact.
But I think in answer to Justice Witt's question earlier, you had confirmed that under the plan, and of course we are disadvantaged in not having sight of the plan, under the plan, nothing is set aside for creditors.
That is correct, my lord.
Wow. So
the reality of the situation was such that the company was to such a large extent compromised. Save for creditors who were actually ongoing, there was nothing set aside in the plan in relation to creditors.
With default judgments, even judgments in their favor. You see, the thing about it is that the way this is shaping up from the point of view you present is that the John brothers are not rewarded at all for their insight, for their assertiveness in asserting their rights, for getting the judgment, for getting into a consent arrangement with CLICO, whereby they'll be paid $75,000 a month. All of that is just washed away, and they get zero. That prima facie doesn't sound very fair, does it?
My lord, I do not believe it sounds fair. I'm not suggesting that it is. I obviously would be well aware that the court is, at the end of the day, interested in some of effective justice, clearly. We are sometimes strong and constrained by legal niceties. And
I am with you, but in that context, and not to interrupt, but in that context of trying to arrive at something that is, for want of a better word, fair or equitable, is there any scope for the parties to talk about this? Because it seems to me that we're heading for a 0-100% game. Either the person gets 0 or they get 100%. Is there not room for compromise between those two extremes?
My lord, I would say the answer is yes. And I am obviously speaking without reference to my client. But what I would like to say in reference to your consideration and the manner in which you have presented it, I think it informed also the Court of Appeals decision, in that they were of the mind that the respondents would be, to some extent, covered by the plan.
Yes, Mr. Ali.
Yes. If it is, my lord, and certainly what informed my client's intent was the need to safeguard, often when I'm in this position and I say the word floodgate, justices tend to dismiss it. But obviously the judicial manager was concerned that this may be the beginning of a number of actions throughout the Caribbean which would have ultimately frustrated the ability to implement any meaningful plan at the end of the day. And hence he took the position that he needed to defend the holistic value for the policyholders versus any one policyholder.
But it now appears to be rather a unique situation, doesn't it?
Okay, I think we have here a number of circumstances that lend themselves to the parties perhaps sitting and talking. On the one hand, the appellant could find out, could end up ultimately getting zero, and that's a rare possibility, given that even the policyholders, which you, Mr. Aline, suggest are the persons who should be preferenced, may only be able to get a small fraction, ultimately, of their investment, and heaven alone knows even when they would get that. So there is a possibility that the appellants ultimately could get zero. There is also a possibility that when we reserve our judgment, we could come out with a judgment in favor of the appellants that will release them to enforce the judgment and to get the full amount which they are claiming, so that the spectrum is vast. There is also the issue which I appreciate, that if we give a judgment and that judgment releases the appellants to proceed, that could encourage the hundreds, thousands of other creditors to also apply to the courts, and with our judgment being a precedent, if that is how we decide, also being released to bring actions against the company. So with all of those in the mix, and I know that Mr. John is hearing what I'm saying, it might be a prudent course for the parties to sit and strive at some consensus, and a consensus which could even include terms that restrict each side from publicizing the terms of whatever consensus is arrived at. If you arrive at some consensus, you can say what you want in that consensus, and ultimately the likelihood is that, it's very strong likelihood is that the court will approve what you draw up among yourselves, and we will put that as our judgment. So if there is nothing more you have to say about the arguments of the appellant, Mr. Aline, what we will do is reserve our position. Yes, I'm advised that I should ask Ms. James to say something.
Yes.
Yes, thank you, Your Honor. Okay, so on the issue of compromising, obviously my clients have shown that they've been willing to compromise in the past, which is what brought us here, because of that willingness to compromise, they did not pursue enforcement proceedings before April 2011. They could have done that in October of 2010. So we are in a position where, even now that we've gotten to this stage, because I must say the question of compromise, if you look at the High Court judgment, that was raised by the High Court judge, where she said, I don't see why the parties couldn't sit down and compromise. What we got was an application for an appeal instead. So there's a question of, yes, we are always willing to compromise, especially if that is the guidance of the court. But we get to the point of how much trust can we put into whatever agreement is obtained. And the other thing that I would say with respect to both said by that argument I think it's very disturbing to hear counsel say that they prioritize policyholders over a judgment creditor, especially when in the order of the court that was just referred to, that created the judicial management on page 109, it says very specifically at paragraph B, which is the very top of page 109 of the CCJ's index, it says that the company should process claims, the judicial manager, should process claims against the company to effect reinsurance recoveries, to pay any class of creditor, and any claims, settlements, and expenses in part or in full, to honor in full the company's obligations on the duty to defend provisions contained in policies issued by the company and to enter into complete contract. So this is where the judicial manager started. It had a duty by order of the court to pay claims, and it did not even, it completely ignored the appellants in this case. And I just want this to be at the forefront of your Honor's mind in any discussion about compromise. Because when learned counsel at this stage can say that there wasn't really a duty to judgment creditors like the appellants, and where there's no money at all set aside, we're quite concerned as to what these discussions might entail. And we heard that the court said it will enforce whatever possible agreement we can come up with, and we want to, so we cannot underscore enough the importance of having the court party to all of these proceedings. And a question was asked of counsel with respect to default judgments or other judgments in the region. And counsel could not say to the court what other judgments exist. We've referred to those judgments. We know of at least one default judgment where the judicial manager in that case, that is the Marlon Hotak case, consented to leave for the persons to bring garnishee proceedings against the company in the amount of something like $500,000. And what happened in that case is that when it was raised at the High Court, at page 362 on the notes of proceedings, you will see that the judge said, in that case, the High Court judge said, that it's quite clear that the reason the judicial manager consented is because the people in that case had a default judgment. And we agree with the judge's opinion on that. And so what the judicial manager could have done in our case is also consent, because that consent was given against the same CLICO company or their subsidiary. And their consent
well, the judicial manager can still give his consent here today in the light of what's being heard at today's hearing.
And as the President said, you don't need to give the details, but a lot of what you're saying, Ms. James, seems to be perhaps better said in the context of negotiations with the other side. I did not interpret the President to be forcing a compromise at all. I thought he was saying that you have an opportunity to talk about it and see if you can come to an agreement. If you cannot, then it's the duty of this court to give judgment, and we will. So I think perhaps a more relevant consideration is the length of time that you think you might suitably, profitably devote to the exercise of talking with the other side. In other words, for how long should the judgment be reserved before we give you a chance?
I understand that. I understand that. I would have to take, my client's leaving for Dominica on Friday. So I would say between now and Friday. But the other thing I would, only because Mr. John, Octavius John, is actually, he was supposed to come here instead of his brother. He's fallen ill, quite ill, and he's not able to travel. And that's why his brother is here. And his brother cannot stay longer than Friday. And it would be difficult for me. I would prefer to have some kind of negotiation before he leaves. But I just want to say, if I can just say one thing.
Is that a bit short?
Yes,
you're saying you're hoping to come to an agreement by Friday?
Well, sir,
yeah, but listen, these are times of modern electronic communication. Even if Mr. John is not physically present, you can have him on the line, you can have him by Skype, you can have him by WhatsApp. I mean, his physical presence with you in Barbados ought not to be an impediment. But if you can come to some agreement this afternoon, tomorrow, Thursday, then that's good, bully for you. The point is that we would give you a generous period of time, let us say 2 weeks to let us know whether you have arrived at a consent in this matter, and or whether you have not. And depending on what you say to us, we will either proceed to give a judgment, which could have one side laughing all the way to the bank, and one side, being very frustrated or disappointed. And it could be either side. Notwithstanding the questions we have asked, we have an open mind on this case. And it is it's not a very straightforward case. So we would make it into... Yes.
Sorry, I just wanted to make one point, sorry. Sorry, Your Honor, just a final point on the question with respect to the assets of the company in Dominica. Just to be clear that we brought this thing here in Barbados, so I'm not sure if we're looking at the assets in the Eastern Caribbean or if we're looking at the assets here. That's the other issue, because without having...
Listen, that's something that you have to discuss among yourselves. We are not going to enter into that issue.
I suppose the reason I raised it is because what was put to counsel is that it's not enough saying that paying out this money in any amount is going to ruin the plan or hurt what's left of the company's assets. And there has to be proof of it, and it's not enough to just say it. And because that's what counsel has been doing throughout, and the case law speaks to that. You have to be able to show specifically how paying X, Y, Z is going to. And he's not done that today. That's all we wanted to say.
My lord, I would like just to clarify 2 points. My friend would have indicated a lack of, and to use her word, trust. And I certainly do not wish the record to suggest that the judicial manager in this matter has acted in any way other than with integrity and has kept all commitments that he has made. My friend raised issues related to the practice of CLICO prior to judicial management, and I wouldn't wish those imputed to the judicial manager. The second element was in reference to a specific authority and the judicial manager's decision to agree a consent order. My lord, as you would be well aware, out of your own jurisdiction, a judgment in St. Vincent is a charge, a first charge on property. And the only property in St. Vincent was proprietary property, a building. And as such, once that judgment existed, there really wasn't any option for the judicial manager. It was going to be the first thing taken off, which is different case in Barbados. A judgment is not a first charge, and that informed his discretion in the matter. I just want that to be clear.
Well, we don't know that because
that's a matter of law.
Okay, so
thank you.
What we will
Lord,
do
I
is
understand the direction to be that we have 2 weeks within which to seek to
we'll give you up until the
settle
6th of we'll give you up until the 6th of March.
6th of March, sir?
Yes.
As your lordship please.
Until the close of business on the 6th of March, the 4th and 5th being days when our registry would not be open.
And you would like a joint communication from counsel to indicate the position, my lord?
A joint communication as to whether the parties have arrived at a consensus or not. If you have arrived at a consensus, then the terms of that consensus so that we can make it an order of the court. If you have not, simply a statement to suggest that you have not.
As your lordship pleases.
Your Honor, my client would like to thank you.
Well, there's also a possibility, I'm advised, that you arrive at a consensus and the consensus includes a clause that you don't even tell us, that therefore the appeal is withdrawn or, compromise on terms which the parties have agreed.
As your lordship pleases.
Thank you, Your Lordships. Your Honor, Mr. John would just like to briefly thank the court.
Yes, Your Honor, I am thanking you all, and I came here today. I came of the Almighty that you all would work in myself and my brother's favor. So thank you very much.
Yes.
For your decision.
Yes, please do sit. You're welcome.
Thank you, sir.
So,
Thank you.
this court will stand adjourned.
Rise.